You see, Dr. McVeigh quotes, "We understand that organisations for sending deprived children to the Dominions may resume their work in the near future. We have heard evidence as to the arrangements for selecting children for migration, and it is clear to us that their effect is that this opportunity is given only to children of fine physique and good mental equipment. These are precisely the children for whom satisfactory openings could be found in this country, and in present-day conditions, this particular method of providing for the deprived child is not one that we especially wish to see extended. On the other hand, a fresh start in a new country may, for children with an unfortunate background, be the foundation of a happy life, and the opportunity should therefore, in our view, remain open to suitable children who express a desire for it. We should, however, strongly deprecate their setting out in life under less thorough care and supervision than we would have at home, and we recommend that it should be a condition of consenting to the emigration of deprived children that the arrangements made by the government of the receiving country for their welfare and aftercare should be comparable to those we have proposed in this report for deprived children remaining in this country." The report further stipulated, "The emigration of deprived children should be subject to the condition that the receiving government makes arrangements for their welfare and supervision comparable to those recommended in this report." This note of caution expressed by the Curtis Committee was not the only expression of concern about the propriety and effectiveness of child migration to Australia expressed at this time. As Margaret Humphreys has pointed out in her book Empty Cradles, 16 of Britain's leading welfare agencies wrote to the Times on the 24th of March 1948, raising concerns about the system. The British Federation of Social Workers attempted to obtain changes to the bill then going through the Westminster Parliament, which ultimately became the 1948 Children's Act, but were unsuccessful. The topic of child migration remained a contentious one in many areas, even though the institution concerned were still sending significant numbers of children to Australia. In particular, the National Council of Social Services published a report compiled by its Child Emigration Committee, which is undated, but from the internal evidence would appear to have been written between 1948 and 1951, most likely published in 1951. This can be found in the bundle at AUS 4354 through to 4391. This was an extremely detailed report in which the committee examined the historical background to child migration throughout the previous centuries, before turning to the position at the time it was written. It also contained a number of detailed case histories, and it examined the practice of many societies regarding the keeping of records and the disclosure of relevant information to the child at the time, or in later years when the child had grown to adulthood and was seeking information about his or her background. This report repays careful reading, and it is invidious to single out particular portions of it. Nevertheless, there are some recommendations which it made at the time and which the inquiry may wish to take into account when considering the practice of those bodies concerned with child migration. The report looked at how children were prepared for emigration and recommended the resumption of pre-immigration training for the children, and referred to the hope of some societies to reopen their pre-immigration homes which some societies maintained before the Second World War. It commented that, if we could pull up page AUS 4368, at the bottom of that page it says, "Unfortunately, the duration of the pre-immigration stage of the children from this society seems to be usually very short, 1 or 2 weeks only. But such a short time gives no opportunity for giving the children any sort of preparation or training, or for adjusting to the difference between the British and Australian school curricula." At page 34 of the report, which is AUS 4367, the report emphasised the need for pre-immigration training, and although it recognised that the need for such training was less pressing for children who had come from institutions, as they were already familiar with the routine of such a way of life, nevertheless, the report stated, "Yet even for them it is desirable to do something to prepare their minds for the remoteness of the country schools and for the details of the life they are to lead. While it may not be possible to give them any precise picture, the mere enumeration of novel circumstances will help the child to recognise them when encountered and feel prepared. The report also contained a detailed description of the problems that could be encountered during the voyage from the extreme heat and rough conditions that could be expected in areas such as the Red Sea and the Gulf of Aden, as well as a detailed analysis and comments of the type of conditions which children would experience on their arrival. Finally, it dealt with the question of aftercare for children once they finished school. The report contained 38 detailed recommendations, some of which related to conditions in Australia, but 16 of which could be implemented by the societies and by government in the United Kingdom. These can be found at pages AUS 4381 through to 4383 and included: every case should be considered by a selection committee consisting of persons with relevant knowledge and experience. The committee should consider personal and family histories of the child to be emigrated, collected in every case by a qualified social worker. Careful consideration should be given to the advisability of keeping together a family unit where the child has brothers and sisters. The minimum ratio of escorts to children of school age for the voyage overseas should be 1 to 5, with the possibility of a higher proportion for young children. Every escort should have a minimum standard of training or experience in the care of healthy children. Detailed records of the child's early school and medical history, information about his family, and full school report should be sent to the country to which he emigrates. When a child asks about his family, he should be answered truthfully, according to the level of his comprehension. In 1953, the British government sent John Moss, about whom I shall say something more later, to Australia on a fact-finding mission. He and his wife visited many of the institutions to which children were sent. Although his report was critical of some aspects of these institutions, he nevertheless supported the principle of child migration. In 1956, a further fact-finding mission was sent to Australia chaired by John Ross. Again, I will return to this later, but as the inquiry will hear, he expressly criticised 5 institutions, and he attached to his report a secret annex which was not published at the time. In that annex, Ross was very critical of a number of other institutions that he had not publicly criticised because he'd not been to all of them, and the information was not sufficiently strong in some instances to allow him to express public criticism. The Australian federal and state governments took time to respond to these criticisms, and both reports and the responses to them were furnished to the Northern Ireland government. However, although the Australian response was prepared on the 16th of January 1957, the inquiry will hear that the last group of children sent from Northern Ireland by the Sisters of Nazareth embarked on their voyage to Australia on the 24th of December 1956. Apart from a small number of older children who were sent to Australia in 1969, the children who embarked on the 24th of December 1956 effectively represented the end of child migration from Northern Ireland to Australia, in the sense that this inquiry will have to consider. For whatever reason, the numbers of children going from the United Kingdom as a whole to Australia declined significantly during the 1950s. In a debate on the 9th of February 1959, the Under-Secretary of State for Commonwealth Relations, Minister C.J.M. Allport, told the House of Commons that whereas 388 children had emigrated in 1950, in 1958 only 80 had done so. By the end of November 1958, out of nearly 2,000 places available to the United Kingdom, over one half were unfilled, and only 62 children were awaiting transport to Australia. The numbers going to Australia from the United Kingdom as a whole continued to decline very significantly, and by the end of the 1970s, child emigration to Australia had virtually dried up. Before turning to the circumstances surrounding children who were sent from Northern Ireland as child migrants during the period covered by the inquiry's terms of reference, which is 1922 to 1995, I think it appropriate to say a little about developments in Australia and the United Kingdom after 1995. In 1998, the House of Commons Health Select Committee, which inquired into the welfare of former British child migrants, delivered a report which can be found at pages AUS 3001 to 3556 of the bundle. Following publication of the report, the United Kingdom government established a £1 million travel fund, which, the inquiry will hear, has enabled 450 former child migrants to visit their families overseas. A number of former child migrants from Northern Ireland have taken advantage of the travel fund, but before it was established, Child Migrant Trust had reunited 14 former child migrants from Northern Ireland with their families at its expense. In Australia, the Commonwealth Government established a travel fund for child migrants which funded almost 700 visits between 2002 and 2005. In November 2009, the Australian Government made a public apology to former child migrants. This can be found at pages AUS 7122 to 7130 in the bundle. In addition, in Australia, some state governments and religious orders have provided financial redress in various ways. In Western Australia, a state redress scheme has benefited many former child migrants, including some of those from Northern Ireland. However, it appears that not all states in Australia make similar provision. In the United Kingdom, the then Prime Minister, the Right Honourable Gordon Brown MP, made a public apology to former child migrants in February 2010. In addition, a £6 million family restoration fund was announced by the United Kingdom, which allows at least 2 visits by former child migrants. A total of 55 former child migrants, including 16 women from Northern Ireland, have used the fund. Just over half of those former child migrants from Northern Ireland who it is believed are still alive. I'm now going to turn to say something specifically about the operation of child migration schemes in Northern Ireland. As the inquiry is aware, a number of documents have been located by the inquiry research team from the Public Records Office of Northern Ireland. Files from the Ministry of Home Affairs disclose material relevant to child migration from Northern Ireland. In the pre-Second World War period, the Northern Ireland Ministry of Home Affairs policy in relation to the child migration by children from training schools can be seen from the following passage from a letter of the 4th of May 1928, which can be seen at AUS 4421, if it could be pulled up, please. This was a letter by the Assistant Secretary responsible who wrote to the clerk of each County Borough Council and each County Council. He said at the second paragraph there, "In the majority of cases, the disposal of a child by emigration will effect a substantial saving in the sum which would otherwise be expended in capitation grants by the government and the local authority if the child were to complete its full term at the school. But apart from such financial considerations, the Ministry considers it desirable in the interests of the children that, when a suitable opportunity for emigration presents itself, this should not be lost by reason of lack of funds. It will be realised that owing to the present prevalence of unemployment in this country, it is difficult to ensure a means of livelihood for young persons on discharge from certified schools. And it sometimes happens that in such cases, young persons after discharge from the school drift back to a life of crime, a result which might have been avoided had they been enabled to obtain work in the colonies." It is significant that in the response from the Children Act Committee of the County Borough of Belfast, a pertinent point was made about the age of children who should be considered for emigration from industrial schools. And if we look at a letter of the 31st of May 1928 at AUS 4028, we see that the town clerk stated that, in their opinion, it would not be desirable except in very exceptional circumstances, when a child was being emigrated in the care of near relatives, that children under 16 years of age should be emigrated. They quite agree with you, however, that the important consideration in the matter is the welfare of the child. In the 1920s, a number of applications were made to the Ministry of Home Affairs for permission under Section 70 of the Children Act 1908 to permit the emigration of boys from Malone Training School who were coming towards the end of the sentences which they were serving there. These boys had expressed a wish to go overseas, and it appears that at least some were approved. When approval was given, the Ministry would pay up to £10 to cover the boy's fare, to provide him with clothes and some pocket money or landing money. Presumably this was intended to tide the boy over until he could obtain employment. All of these children went to Canada. After the Second World War, the role of the Northern Ireland Government and the Ministry of Home Affairs was largely confined to the Minister considering whether to approve the emigration of children who were in care, either because they were in a training school or other penal institution, or because they were in local authority care. As we shall see, the numbers going from either were quite small. However, the government was well aware of the considerably larger numbers that were likely to be sent to Australia under the child migration schemes which were supported by various Roman Catholic organisations. As these children were not covered by the legislative provisions, no ministerial consent was required. The government's knowledge came from two sources. First of all, the views of the Northern Ireland Government were sought by the Westminster Government in 1949 because of a query raised by the Australian Commonwealth Government concerning the provisions made in Australia for the guardianship of the children who were sent from the United Kingdom and the meaning of the term guardian in Section 17 of the Children Act 1948, an act which did not apply in Northern Ireland. Correspondence can be seen at pages AUS 4081 through to 4083. I don't propose to open that correspondence, but that shows that the Northern Ireland Ministry did have knowledge. The Ministry of Home Affairs decided that they would apply the broader definition of guardian applied in England and Wales and not the limited Scottish view. The position of the Ministry was set out in a letter of the 13th of February 1950 at AUS 4089, if that could be pulled up, please. It's stated there, the second paragraph, "Our Children and Young Person Bill will enable a welfare authority to procure or assist in procuring the emigration of any child in their care, but where the child is capable of giving his consent, such consent will be necessary. Where the child is too young to form an opinion, he must emigrate in company with a parent, guardian or relative, or must be emigrating to join a parent, guardian, relative or friend. In all cases, the parent's consent must, where practicable, be obtained, and the Ministry's approval will also be necessary in each case. As regards children in training schools, the managers may, with the child's consent and with the consent of the Ministry, arrange for his emigration and must, where possible, consult with the child's parents. The Ministry felt that should a limited definition of guardian be applied, then as feared by the High Commissioner in Canberra, we can see this at page AUS 4082, the consequences will be a virtual cessation of the migration to Australia under the auspices of and for placement with voluntary child migration organisations approved by our respective governments, or children maintained whether wholly or partially by local authorities responsible for the Scottish Home Department. It is also clear from a memorandum of the 2nd of January 1950 that the Ministry of Home Affairs was well aware of the nature and scale of Roman Catholic emigration under child migrant schemes because they were informed of this by the Australian Catholic Immigration Committee, the ACIC, one of the bodies responsible for child migration. The ACIC wrote to the Ministry in 1949 and sent with that letter a copy of the ACIC Committee Quarterly Progress Report on Child Emigration for Scotland and Northern Ireland. It can be found at pages 4078 and 4079 in the bundle. When the Northern Irish Children and Young Persons Act 1950 was being drafted, the Ministry considered whether to incorporate in Northern Ireland legislation similar powers to those granted to the Secretary of State in Great Britain to control the making and carrying out by voluntary organisations of arrangements for the emigration of children. In a memo found at AUS 4085 through to 4087, it is recorded, "We did consider a similar provision for our legislation, but the parliamentary draftsman thought that we would be prohibited from doing so. The whole question is more likely to arise in connection with voluntary organisations than in relation to children in the care of welfare authorities." This suggests that a deliberate decision was made by the Northern Ireland Government not to include a similar provision requiring ministerial consent for the emigration of children in the care of voluntary organisations in Northern Ireland. We can see the operation of the policy from papers obtained from the Public Records Office for Northern Ireland. I intend to summarise these and refer to the pages in the bundle but not open those pages. In May 1950, the St Patrick's Boys' School run by the De La Salle Order put forward several boys as candidates for emigration to Australia. All of the applicants except 3 had completed their period of supervision. Therefore, only the 3 candidates who were still under detention, all of whom were almost 17, required ministerial consent by virtue of paragraph 7 of Schedule 4 to the Children and Young Persons Act 1950, Northern Ireland 1950. Ultimately, the minister's consent was given and all 3 boys emigrated. The consent can be found at AUS 5923. It is unclear exactly how many boys ultimately went to either Canada or Australia by virtue of the provisions which governed emigration from training schools, but all the boys, both before and after the Second World War, were close to adulthood. It is also relevant to point out that none of those who have spoken to the inquiry were part of these schemes, and therefore the inquiry may consider that their circumstances do not require further examination. Only a small number of children in the care of county welfare committees were put forward for and ultimately given approval for emigration. In 1951 or 1952, a child who appears to have been 15 or 16 and to have been boarded out by Antrim County Council was accepted by the Big Brother movement. Details in relation to that can be found at AUS 5167. In November 1956, there is a report noted by County Down County Council on the 30th of November 1956 of a boy being at Doringley, although there's no other record in relation to his emigration being found. We see that at AUS 5006. In April 1964, Belfast County Borough Welfare Committee sought authority for a boy of unspecified age to travel to Australia under the auspices of the Big Brother movement to join his foster parents. But it appears that he did not emigrate because he was turned down by the Australian Chief Migration Officer in July 1964. Details can be found at AUS 4349 and 4350. In 1965, 2 boys were apparently given permission and financially assisted in their emigration to Australia, AUS 4349. Although these children all fall within the ambit of this inquiry, so far as can be ascertained, they were all in the 15 to 18-year age bracket and were of an age when they could make an informed choice as to whether they wished to go to Australia. Several seem to have taken the initiative to do so. In addition, the inquiry has not received any complaint from any of these children and therefore does not consider it necessary to examine these emigrations further. Several children known to have been in the care of welfare committees were sent to the Presbyterian Foundation in Doringley in New South Wales. AUS 5134 shows that in 1952, 3 brothers were put forward by County Armagh Welfare Committee for emigration to Australia. Although it is not expressly stated they were sent to Doringley, it appears highly probable because there is a reference to them being sent to a Church of Scotland, that is Presbyterian Foundation. It is noted that they sailed on the 11th of June 1952 and the arrival was reported on the 28th of November 1952. The ages of the children are not stated, but it seems probable that 2 of them were well into their teens because they're both described as working and were therefore presumably no longer of school age. The age of the 3rd brother is not stated, however, he presumably was still of school age as no reference is made to his working or being available for work. In 1950, Belfast County Borough Welfare Committee considered sending 4 or possibly only 3, the wording of the entry is ambiguous, but no document has been found to confirm whether they were sent or not. That's AUS 5151. We do know that in November 1950, 10 children sailed on the same vessel, all of whom came from either County Welfare Committee care or from the Protestant-run home at Manor House, Lisburn. 7 of the children came from Manor House, 3 of whom, HIA 354, who stayed there for about a week prior to emigration, HIA 341 and HIA 346 are applicants to this inquiry. HIA 431 and 341, I beg your pardon, and 346 were at Manor House. HIA 354 was in the care of the County Tyrone County Welfare Committee at the time. Although HIA 354 is the only child from the state care sector in respect of whom there appear to be a complete or at least a very substantial series of references in available records, his history as documented is of considerable significance for a number of reasons, and later this week those documents will be examined in greater detail. The history of his involvement with Tyrone County Welfare Committee and Doringla is significant because it shows, 1, that this local authority considered that it was essential that they should be informed of the progress of the child whom they had assisted to emigrate, and they did not therefore wash their hands of him. 2, that over several years they made determined and persistent efforts, which ultimately paid off, to ensure they did receive information about his progress. 3, unfortunately, it also suggests that there was information which caused the welfare officer to alert the welfare committee to concerns about the way children were being treated at Doringla. Insofar as it is possible to judge, the committee appears to have been reassured by an account given to it by the Reverend Bell from that home, although it may simply be that they would not have sent any other children anyway. Nevertheless, it is significant that the reason why the county welfare officer later gave for not being prepared to recommend children to go to Doringla was because he had not been able to obtain reports on HIA 354's progress, not because of any other concerns that he may have entertained at some stage, because of the disquieting reports he had received. However, given the passage of time, it is not possible to put the matter any further than that. But as I have said, we will look in detail later this week at the documentation from Tyrone County Welfare Committee. I turn now to examine the involvement of the Congregation of the Sisters of Nazareth in the child migration schemes. The Sisters of Nazareth were involved with child migration well before the children who are being considered by this inquiry were sent to Australia. From a perusal of the General Chapter Minutes, it appears that the congregation sent children to Canada in or before the 1920s. In 1923, the General Chapter considered an approach from a Major Macaulay, who suggested that the sisters might send children aged about 12 to Australia. If we pull up, please, AUS 5386.